Sorry, sir.
Don't
Very
worry.
heavy chair.
Here in the matter of Banks and the Commissioners for Her Majesty's Revenue and Customs Department.
Yeah. Yes, Sir James.
I've handed up 3 documents. Can I come to them in turn when I reach that the relevant point?
Of course.
I'll explain what they are.
Yeah.
I wanted to wrap up associative discrimination before moving to justification. The procedural position in relation to that one, this is the claim built on UKIP, as it were.
Yeah. Yeah.
The procedural position in relation to that is that in the claim based on Article 14 taken with A1P1, the appellant has never sought to rely upon UKIP's position prior to the Court of Appeal's skeleton. The reliance on UKIP's rights before was restricted to Articles 10 and 11, and those claims see for that purpose the Upper Tribunal judgment at paragraph 202. Then in the skeleton for the Court of Appeal at paragraph 30, the appellant suggested that he was entitled to rely upon a breach of UKIP's rights in respect of his Article 14 with A1P1 claim, but without setting out at all what that claim was. There was no reference to associative discrimination or the passage from Simawi on which reliance is now placed, which I'll come to. And our submission, briefly, on the procedural position is therefore that the appellant has no permission to run this new claim, new way of putting it, and the Court of Appeal should not permit it to be run at this stage. But in case you are against me on that procedural position, I wanted very briefly to address the merits.
Well, whatever we determine, it's probably better to deal with it on the merits as well.
Yes, that's what I'm planning on doing.
Yeah.
So you have all the options available to you.
Absolutely.
So far as the merits are concerned, UKIP is obviously not a party to this litigation. And you know from the provisions in the HRA that my learned friend took you to yesterday, that in order to mount an HRA claim, someone has to establish that they are a victim. 7.1 and 7.7 of the HRA. And we respectfully submit, first at least, that there is authority to suggest that association with a political party is not sufficient to allow someone to rely upon a breach of that party's convention rights. The authority for that proposition is in Bundle 1 at tab 11, and it's a short passage in a case called Lindsay in the United Kingdom. So Bundle 1, tab 11.
Bundle 1. Tab 11.
Tab 11.
Yeah.
Might be worth just casting your eye down the first page, page 135, just to get a flavour of what the case was about.
Yeah.
You see the context, and then the paragraph I wanted for this purpose, not going to read it out, it's a relatively short passage in an inadmissibility decision, so they're taking victim status as the admissibility point. Paragraph 3, which I hope is sidelined on page 137.
Yeah. Shall we read that for
Can I
ourselves?
invite you to do that? This thrust will be obvious. So there's a victim concern at the outset, but come to the merits, if I can put it that way.
Yeah.
My learned friend relied on the passage from Lord Justice Lewison in Simawi, as you will recall. I just remind you of the reference without inviting you to go back to it, because I'm going to show you the Strasbourg authority which was cited. Simawi is at bundle 2, tab 49, and the relevant paragraph for this purpose is 28 in the judgment of Lord Justice Lewison. And he relies upon a case from Strasbourg called Guberina and Croatia, which is the first of the documents I've handed up, for the proposition that an individual can be treated less favourably on the basis of another person's status or protected characteristics.
Yeah.
So the limited proposition for which Lord Justice Lewison limited correctly cited the authority was that it was possible for there to be associative discrimination. The question, however, and the key question, is in what circumstances that will be allowed, and you won't be surprised to hear me say that the punchline of all of these submissions is going to be that a remoteness question arises. How close is the connection? Is it sufficiently close for the relevant purpose to allow this sort of claim to be made? And for that purpose, one goes to Guberina. You could take that up if you would. The complaint in that case was that in failing to give him an exemption from property tax, the state had failed to take into account the specific accommodation needs of his, that is, the applicant parents' family, due to his child's disability, the child not being an applicant, contrary to A1P1 read with Article 14. So that was the context, and the relevant passage, for present purposes, is a relatively short one, which again I'm going to invite you to read rather than reading it out, which is at paragraph 76 through to 79. I think it's page number 23 if you go on the page numbers on the bottom.
Yeah.
The right-hand corner. So 76 to 79 if you would. And the key passage is really 79. One can, as it were, transpose that reasoning into the case that my lady will remember, the C case. One would have something rather similar if the applicants had split differently and the father was or mother was making the claim on behalf of the child. It's a similar sort of idea, but it's about the family unit and the degree of closeness there. What is being claimed, in effect, is the claim by the adult for state money on account of the child's disability, which is obviously...
Yeah, you can understand why that sort of case would fall within other status.
Exactly so. But one can't cite Guberina and Croatia for the breadth of proposition which my learned friend needs, which is that whenever you choose as an applicant to assert an association with a third party, that's enough for the purpose of establishing the requisite degree of connection. And the appellant's case here has got to be that he can rely upon this line of authority, which is plainly not applicable as broadly as he would like. He can rely upon the fact that he chose to donate to a party that didn't have an MP and therefore didn't meet the Section 24 conditions. And my submission is that that is altogether too remote to fall anywhere close to the principle established in Guberina and Croatia.
But in any event, Sir James, if you're right in your primary submission yesterday, that the difference in treatment is a consequence of lack of success, then the same reasoning would apply mutatis mutandis to UKIP.
That's the first in any event point. And the second in any event point, is that even if that is wrong, it places you, as it were, on the far reaches of Lord Walker's concentric circles. I wanted to show you one other authority for the purpose of trying to make good the idea that what I describe as remoteness of connection is a relevant and applicable principle in this context. And it's in the judgment of, might even be speech, I have to check the dates when I get there, of Lord Hoffman in Gallagher, which is Authorities Bundle 1, the same one you've got to hand, hopefully, tab 24.
It'll be a speech, won't it?
It will be, yes, it will be speech, because it's UKHR. So,
yeah.
and you'll see the nature of the issue that they were considering this was a challenge to the various forms of rating, I think, in relation to religious buildings. You see the relevant provision in paragraph 2 of the speech, in the quotation, and really the phrase you need is the last phrase of substance in sub 1, so it's public religious worship. And the argument effectively centred, with the argument of interpretation, centred, as you see from paragraph 5, around the argument, as one sees from the first line of paragraph 6, developed by Mr. Sumption with great skill and learning, that when it said public religious worship, it didn't actually mean public, it meant something else, which is private. So the difficulty with that submission was not, it appears, a difficulty of principle on which Lord Hoffman seemed capable of persuasion, but that the point had been definitively decided some years earlier by the House in a case called Henning, see paragraph 8. Anyway, that's not the bit I wanted. The bit I wanted was paragraphs 13 and 14.
Yep.
And can I just invite you to read those two paragraphs with particular emphasis on the distinction drawn in 13, which emerges very clearly from the penultimate sentence of 13, and the punchline which is in the final sentence of para 14. But if you read both paragraphs, the point I wanted to make will, I hope, be obvious. Indeed, I probably should have taken you to those two paragraphs yesterday, because they're very much the principal basis for the theme that says, look at the true ground of distinction that is created by the legislation. But they apply equally at this point that we submit. Just to save me going back to it later, you'll also note paragraph 15 whilst you're there. Flagging justification. So that's our first point, and I've already made, in answer to my Lord's question, the two in any event points, which you have.
Thank you.
My lords, my lady, therefore, that is discrimination. I wanted to turn, if I may, to justification as the next topic.
Yeah.
And I start with the approach in principle, although this again will be very familiar territory to all of you, I know. And the first submission I make on the approach in principle is that in principle, manifestly without reasonable foundation is the right test. And you will all appreciate that as a test, it reflects, as a test, contexts in which the underpinning for a very considerable degree of respect to parliamentary judgments is in play. And of course, the principled underpinning, which dictates the breadth of respect in any particular context, are now also very clearly established. We'll see them specifically referred to in Lord Justice Singh's judgment in Drexler when we get to it. But they are, to coin the phrases, I think, taken from Lord Sumption in the Lord Carlisle case, institutional competence, which of the pillars of state is the right body to be making the sort of decision in question, and democratic legitimacy. And the reasoning in the case law is very clear. Manifestly without reasonable foundation is a tool that is used to take the language from Lord Carnworth in the DA case, Bundle 2, tab 45, at paragraph 118. As he put it in that case, manifestly without reasonable foundation is a tool that is used, quote, as a means of allowing the political branches of the Constitution an appropriately generous measure of leeway when assessing the proportionality of measures concerning economic and social policy. 118.
Yeah.
And it is to be noted that that case also, don't need to tell out the passage, I don't think it's in dispute, that case also finally put to bed the idea that manifestly without reasonable foundation as a test only applied to certain parts of the four-limb analysis.
Yes.
The Supreme Court decided in terms that it applied across the board, having perhaps after an earlier Supreme Court hiatus in the asbestosis case in particular, which suggested that there might be a difference in relation to some of the stages of the analysis as between legitimacy of aim and proportionality. But it applies across the board at all stages. I wanted to take you to three recent Court of Appeal cases very briefly. The first one in order of time is Drexler. That's the one I referred to earlier. That's in, if you put bundle 1 away and get bundle 3 if you would.
Yeah.
I want paragraph 50, tab 53. And the lead judgment with which Lord Justices Newey and Bean agreed was given by Lord Justice Singh. This is about special educational needs provision and guidance, and so not about the usual benefits context, which itself is perhaps of some significance. Yeah. And the passages that I wanted that we would invite you to read are pretty much the long section from paragraph 51 on 1991 at the bottom, right the way through to paragraph 75 on 1996. I don't suggest that you read them all now, but you will see that the submission was made in terms and rejected that DA was only concerned with welfare benefits.
Well,
Rejected the paragraph.
Found in terms, paragraph 70, that manifestly without reasonable foundation is not limited to, well, there's no authority, binding authority, that's limited to welfare benefits.
Yes, and the rejection earlier on, at paragraph 52. But you see the familiar principles being considered, the scope of the margin varying according to the circumstances, the subject matter and the background. That one sees that approach in Strasbourg and in the domestic authorities. You see from paragraph 54, second half of 54, beginning the European Court of Human Rights, as frequently said.
Yeah.
Then you see the distinction drawn on the basis of suspect grounds or not. Paragraph 55, citing Carson as an example of a non-suspect ground because it was to do with residence. And then, very importantly, perhaps for present purposes, paragraph 56. And you'll see the emphasis in particular at the top of 1993, institutional competence, democratic legitimacy, which are the two underpinnings determining the breadth of the margin that is afforded or respect whichever concept one chooses to use. And why is it that scarce and finite public resources is inherently attracting a wide margin? It's because they call for political judgment. That's why, those are the reasons why a broad margin is afforded. And then coming directly at 59 to confined to welfare benefits, goes through all of that and rejects the submission, and does so not merely identifying the fact that there is no authority in the Supreme Court determining otherwise, and that all the Supreme Court authority that they there cite and was cited to them, no doubt in support of the proposition, is to do with different things and therefore obviously distinguishable, but identifying the fact that there had been a trilogy, even at that stage, of Court of Appeal cases in which the proposition had been rejected, including Simawe's 1Cs from 72. So that's Drexler. JCWI is at tab 54, the next tab. And the relevant passage is the passage you were taken to yesterday from, it's all sidelined from 125 on page 2042, at least up until the end of 134. If I can invite you, at least notionally, to continue that sidelining, if that's permissible, even if it's not, it gives you more to read, as it were, but you really should read to the end of paragraph 140. So it's really 125 to 140 contains the totality of the relevant analysis. And just to try and extract the key principles in a nutshell, the core passages we submit are to be found, and I suspect that my lady saw this one coming yesterday, perhaps there was anything to go by, 133 sub 4. Yeah. That's the answer in principle. And just to correct a submission that my learned friend made yesterday, he said, well, Lord Justice Higginbotham did not apply MWRF. He didn't feel the need to determine the issue finally because the outcome would have been the same. But just note the first sentence of para 134, if you would. That would have been, if necessary, his answer to the question of principle which myself and Miss Kaufman were debating. But 1334 is critical in principle, and then the second passage, which is critical, is at 140. With all of the themes with which the court is now familiar from Lord Justice Leggett's judgment in C, cited at 138 and 139, all of them, as it were, bundled up, or the key ones bundled up in one place. So those are the two key passages from JCWI indicating the correctness of the approach and why that approach is correct. MWRF outside benefits, and whenever you're dealing with social or economic or political issues and the constitutional underpinnings of that. Then the third in the trilogy is Delve. And that's in tab 55. And the relevance, that was about pensions, as you know, and the relevant passage is the sideline one starting at paragraph 86. And this is interesting because, apart from anything else, a full-blown attempt was made to say that MWRF wasn't the right approach to be taken in a case like that, because Strasbourg had produced, the Chamber in Strasbourg had produced the judgment in J, D and A, and that was rejected because there was binding Supreme Court authority in DA. See paragraph 88 for that proposition. And you will see, in particular, their conclusion about how the concept of MWRF operates. The very short paragraph agreeing with the submission that I've made in that case, at paragraph 93. And you see the way in which they put that, the measures dealt with controversial matters of huge political weight and clearly fall within the macro-political field. So it's not just benefits, it's not just economic, it's whenever you end up with those constitutional principles in play. So we respectfully submit, and that's all of a piece with earlier authority which is cited in some of these cases, including Simawi on justification, which I don't go back to, but we submit that what that case law demonstrates is that MWRF is applicable here on the basis of the correct approach in principle. It isn't coherent, as Lord Justice Higginbottom pointed out and as repeated Court of Appeals have pointed out, to seek to confine it and the breadth of margin it affords simply to particular types of nominated context. It applies if the principled underpinnings are engaged. That's the short point. And that was the clear and express reasoning of the Court of Appeal in that trilogy of cases. I should note on this first submission, which is in principle MWRF is the right test, that there's been no attempt to argue in this case that as a result of J, D and A, there is some alteration of approach. There was some suggestion, as you saw from, in particular, the Delve case, that J, D and A should be taken as a broad proposition that MWRF only applies to transitional provisions. That is, as the Court of Appeal there held, entirely inconsistent with the reasoning and approach and conclusion of the Supreme Court in DA.
The reasoning in paragraph 88.
The reasoning in paragraph 88.
Apply the same reasoning here.
By the same
if
reasoning,
that argument were run,
yeah,
the answer is the same one was given by Master.
One could add for good measure that analysis, if it's to the extent that it truly represents the reasoning, is self-evidently wrong in any event. Yeah. One only has to think of Carson. Carson in the UK, that had nothing to do with transitional provisions.
No.
And both the domestic courts and Strasbourg applied that as the approach. The second submission is one which is an alternative, and that is that the features in this case, in any event, mean that whatever test is applied will make little difference whether you apply MWRF or you apply conventional proportionality, because even if you apply the latter, you still have to give, as an integral part of that approach, appropriate weight and respect to particular types of decision by particular types of constitutional body. And that's perhaps unsurprising, because manifestly without reasonable foundation is no more than a convenient label for describing the breadth of discretion which is afforded to the relevant constitutional actor. And that was the approach. I don't need to decide it because the answer is the same, because the factors are the same. That was the approach that was ultimately taken in Drexler, see paragraph 76. It was ultimately also taken by Lord Justice Higginbottom in JCWI. Yeah. And that is the approach that the Upper Tribunal took in this case, which respectively doesn't make any difference. So those are the two submissions of principle about the correct test to be applied and approach to be applied. What then are the features here? What are the key features in our context? 6 of them we submit. Firstly, the context here plainly attracts the broadest margin. Taxation policy is a matter of economic policy, and that at base is what we are dealing with. One only has to examine the essential question: when is it appropriate to escape from otherwise applicable taxation through an exemption? In other words, when is it appropriate to diminish the public purse, which would otherwise be swelled by the taxation, by the grant of an exemption? That's a fundamentally economic question. And so the taxation context is itself important as part of the context attracting the broadest margin. And as you are well aware, as my Lord Justice Henderson pointed out yesterday, tax measures are traditionally and have traditionally been afforded a very significant respect and margin. If you wanted authority for the self-evident proposition, row is in the authorities bundle in bundle 2, tab 42, at paragraphs 197 to 200 for that proposition, but it's very well established. Secondly, even if you take it up a stage, still on this, on the features of the context, and you say, well, this is all about judgments about when a state should fund, by providing tax exemptions, political parties and how that should be set up, you still end up with that being a feature tending towards broad margin rather than not, because that set of questions engages issues of a core social and political kind. So when you double them up, you have the use of taxation policy to achieve what Parliament has decided is a public good, which is the private funding of political parties. And you saw the passage from paragraph 15 of Lord Hoffman as an example of exactly that sort of context. So it's high political and social sensitivity. My learned friend at one point in his submissions appeared to be suggesting, well, this isn't economic, but it's political. The difficulty with that is twofold. The first difficulty is that it's wrong, because tax is self-evidently economic. But the second difficulty is that it simply jumps him out of a sizzling pan into an equally sizzling fire, marked political. So we respectfully submit that for all of those reasons, the first submission is that the context with those features attracts the broadest margin. Secondly, and perhaps as a follow-up to that point, but I take it separately just for convenience, it is not possible, we submit, for the court to say what choice Parliament should have made. What percentage of the popular vote it should have used instead. Should it have been 1 MP or 2? Should it have been the last general election or other general elections? And the answers to those questions are ones which there is really no yardstick against which a court can judge what are essentially political questions, or, if you will, legislative questions. And that was very much the thinking, if I've correctly read Lord Justice Legate's judgment with which the other members of the court agreed in the C case, that was very much the thinking, and indeed the dispositive analysis, part of the analysis of Lord Justice Legate in C. Can I just invite you to take that up? It's in Authorities Bundle 2, sorry to jump between them. Tab 44. And I wanted in particular for this purpose, paragraph 129, and I just invite you to read that to yourself. And then 158 on page 1575. So 158, I think all we need for present purposes is the first 3 sentences. First 4 or 5 lines of 158.
Yeah.
which takes one back by reference internally to paragraph 87 on page 1555, which is the final port of call for this purpose.
'87.
87, 1555. You'll see there's a few themes in there, but the second point I therefore make is that it simply isn't possible for a court to jump in and say, well, it should have been 2 MPs
Yeah.
or 3 MPs or 150,000 votes or 155,000 votes. Just, there's no yardstick. The third proposition is that there is no consistency at all in the contracting states to the ECHR, the members of the Council of Europe, on the issue of what criteria a party has to meet in order to qualify for state support. It's enough simply to assert that fact, which the Upper Tribunal noted at 191, that there appears to have been quite a lot of consideration below, but none of my learned friends all submissions of the Venice Commission guidelines, dealt with, we respectfully say, correctly by the Upper Tribunal in 193. But perhaps more interestingly, for the purpose of this point, the Neal report contains an appendix which surveyed a number of foreign countries' models for party political funding. See Authorities Bundle 3, tab 58, page 2159. And the key points to emerge from that appendix and that comparative survey are that every country uses some minimum threshold of electoral success to qualify for state financial aid, but every country uses different different criteria. And that no doubt reflects their basic electoral or election setup. But the fact that there isn't any consistency across Europe as to how you go about doing this is itself a feature which tends towards very considerable margin being afforded to each contracting state to do it as it sees fit in accordance with its historical traditions and the way in which its political institutions and election systems are set up.
Obviously, there's one difference between the United Kingdom and many other countries within the European Union is that they don't have first past the post. But as my Lord said yesterday, the moment you start wading into that issue and saying, well, the criterion ought to be something different because our first past the post system is not fair to UKIP in these circumstances, Mr. Coppell's essentially inviting the court to exercise a political judgment, which is not for us at all.
I'm going to come back to the first past the post system, but I essentially agree. Yeah. I respectfully agree with that. Anyway, the fact that there is no European consensus as to how this works is a factor tending towards the broader margin. Yeah. The fourth point is a simple one. The measure is contained in primary legislation. See, for that purpose, if you want authority, Lord Justice Leggett in C at paragraphs 92 and 93, and Lord Justice Higginbottom in JCWI in the paragraph I highlighted, paragraph 140. And here, of course, if one is then dealing with the follow-up question under this head, it's been produced by Parliament, it's contained in primary legislation. My learned friend Mr. Coppell then says, well, it's relevant as it is to take into account whether Parliament has considered the particular issue before the court as the way in which it's put by Lord Justice Leggett in paragraph 93. But the position, that's his factor 2, I think, but the position here is of course, that the lines in section 24.2 are entirely clearly drawn. It will have been absolutely clear on the face of the legislation that the lines were being drawn on the basis on which they're being drawn, with the result that neither individual nor political party will benefit unless the minimum standard of success as defined is reached. This isn't some hidden or unappreciated or unconsidered discriminatory impact. It is the essence of what is a simple provision on the face of primary legislation. So
and for what it's worth, it doesn't take first past the post success as the only exclusively relevant criterion because of the 150,000 votes alternative under the second limit.
That's true. But the core point for present purposes is if you're looking to shrink the margin on the back of a contention that Parliament didn't really see what it was doing and didn't really think about the discriminatory impacts, the lines that are being drawn on the face of the legislation are crystal clear, is the short point. And in any event, it is at least worth bearing in mind that when one gets to proportionality, see the learning from, in particular, and first, I think, Lord Wilson in First County Trust, you judge proportionality, as it were, objectively, by reference to the nature, content, and effect of the legislation which you are considering and which is under challenge, rather than by reference to the adequacy or otherwise of the debate, still less speculation about why MPs might have voted for a particular provision or not. So proportionality is a stand-back, objective exercise of the court in that sense. But on the face of it here, there is no basis whatever for shrinking the margin on account of an unconsidered set of provisions, because the nature of those provisions was evident on the face of the legislation, and still Parliament enacted them. That's the fourth point. The fifth point, which I will come back to later in the context of a broader proportionality and rational connection and so on, is that despite a series of reviews, and I'll give you details when I come back to this point, but despite a series of reviews, Parliament has evidently decided, for whatever reason, not to change the system under 24.2. And I should add for good measure that I do not accept that there has been any change of heart by Parliament or indeed by the government. But the 2016 statement, which my learned friend relied on at the outset and then came back to, which referred to fairness and consistency, cannot properly be read as a conclusion that even the government had concluded that the present system was unfair or inconsistent. It's cast in the positive, and the flip side does not follow, that the present system does not pass muster. But in any event, and however you choose to construe that statement, the fact of the matter is that the relevant constitutional actor here is Parliament. And it would be no good if the government stood up and said, well, we think this system is absolutely marvellous. Carry no weight at all, because the relevant constitutional actor is Parliament, and it's evidently decided not to change, despite lots of reviews of this area, lots of consideration, including, as you will recall, parliamentary debates to do with whether 24.2 should be introduced in some form in the context of an income tax exemption. So the territory has been looked at, and the provision remains. The sixth and final point that we make in relation to margin, or area or leeway, area of discretion or leeway, is that the discrimination here is not on a core or suspect ground, very far from it. That was my learned friend's factor one. And I flagged yesterday that the submission was going to be, and I now make it, the submission is that precision is needed. The cases that cited and the authorities that you've seen do not establish that as long as political opinion is in the frame in whatever way, the ground is suspect. Political opinion is a broad church, and there is, we submit, an analytical necessity to consider which part of that church one is actually dealing with. And the reason for that analytical necessity is because, depending upon which part of that church you're in, you may be closer to or further from the core values which political opinion and its coverage protects. Here, therefore, there is nothing whatever in the provision that you are considering to stop, prevent, or hinder any form of debate, any form of expression of view. There is no trammel on the association with any party, that's political party. There is no trammel on membership of a political party, so you are not within the reach of Lord Hoffman's paragraph 15 in Carson, tab 17. We are here dealing simply with encouraging donations through the creation of a favourable tax exemption. And moreover, we are doing so even then, not on the basis of political views, but simply on the basis of success. This is not, therefore, on any view what Lord Justice Leggett described in C as an important aspect of an individual's personality in the sense of what makes someone the person who she or he is. Back to Lord Walker's concentric circles and how that analysis works. We are simply not close to that. So the submission is that what you can't do is just to take political opinion and ascribe a uniform set of suspicion to all forms of engagement with it. What do you actually
I mean, the way it was being put was making a gift to the political party one supports is a natural and obvious way in which to manifest one's support for a political party, and in that sense, it is linked to a core value, which is the right to hold political opinions.
And my lord, I would accept that.
Yes,
it's a statement of the effect of the provision.
Precisely.
But the question is how it goes about doing that and what is not done. And often when you go into the cases that may treat political opinion as a suspect ground, you're dealing with, you know, communists not being afforded housing or whatever it may be, or banning membership or associations.
Right. But there's absolutely nothing to prevent Mr. Banks from manifesting his support for UKIP in any way he chooses.
Including giving them a donation.
Including giving them a donation. The only consequence is he may have to pay tax if he gives them more than exhausts his nil rate band for the time being.
Exactly so. So the submission is really no more than a plea to understand fully exactly what the measure that you are considering is doing, and not, as I say, to ascribe a uniform band of suspicion simply because you can say that you are in territory in which it's a manifestation of political opinion to give.
And what comes back to the point, the legislation is crystal clear, so he can't have been under any misapprehension about the tax position. At least if he was, he can only, would only be for not reading the provision.
Exactly. So we respectfully submit that the assertion that this is a core ground is based on that faulty analysis, the overgeneral analysis.
Perhaps it really comes back again to your key causation point. I mean, if there is any prejudice here, it's not caused by his support for UKIP, as opposed to
the lack of success
of UKIP or any other party he happened to support.
It does come back a bit to that in part, but this submission is being made as a ground or a reason for demanding under justification the very weighty reasons that you would do if you were, for example, directly discriminating on the grounds of sex.
I follow that. I was perhaps really reflecting the point I think you made yesterday, that underlying point you began with does have an influence on pretty much everything that follows.
Yeah, it does. It does. And in part on this. So, my lords, those were the 6 points on margin and approach in principle and so on. It is perhaps just worth going through the stages of the analysis, if only briefly, to pick up some of the specific points. And I start with legitimate aim, recognising, as I say at the outset, that MWRF applies at all stages of the the analysis, but start with legitimate aim. What has to be justified? And of course the position is, as we both agree, that if the focus is on direct discrimination, then the focus for the justification analysis is on the reason for the difference between the relevant comparator groups. If it's indirect discrimination, it's on the justification for the measure itself. So there's no dispute about the basic proposition or dichotomy. The submission that we make, however, is that in our particular context, because this is as I said yesterday, a slightly strange provision, as it were, to put the slippery taxonomy for discrimination on top of, there is no distinction between those two approaches here, and none is really suggested. And that is for the simple reason that the aims are evident on and from the face of the legislation. They are the lines drawn by the legislation and the distinctions that are thereby created by the lines. And the question is whether they are justifiable. So essentially the same question arises whichever framework, direct or indirect discrimination, is engaged. Why are the lines drawn as they are? Essentially focusing on the fact that only donations to successful political parties are within the exemption. So that's the initial point under legitimate expectation. So far as the basic analysis of legitimate expectation is then concerned, my learned friend's main point appeared to be that there is a key split out between the objective or the aim of the measure and its effect. And of course, there may be a difference in principle between those two things, as the authorities establish. But we would make 4 points in answer to that basic case being made by my learned friend. The first is that the court's aim, or the court's purpose, is to seek to ascertain the aim or the purpose of the legislation. And the correct approach to that exercise is to discern that purpose from the provisions that Parliament has actually enacted. Can I invite you to go back to Lord Wilson in the First County Trust, which is in tab 15 of Bundle 1. So Bundle 1, tab 15. And I want paragraph 61 first of all.
Yeah. Yeah.
So tab 15.
Sorry, getting there.
Right.
Very heavy bundles.
Very heavy bundles, right. Paragraph 61 on page 277. And I really wanted, just for this purpose, the last two sentences. What is relevant is the underlying social purpose sought to be achieved by the statutory provision. Frequently, that purpose will be self-evident, but that is not always so. And what is the correct approach to ascertaining that purpose or aim? Well, for that purpose, you need to go to paragraph 67 on page 278. And of course, what they were considering directly here was in effect pepper and heart and how it works under the HRA. And so they were considering the use of Hansard as a source of background information. So of course you can ascertain purpose by looking at a broader range of pre-legislative materials that would ordinarily feature. You can look at Hansard for this purpose as it were another HRA type exception to pepper and heart. But if you just look at the correct approach in 67 and you take it from 4 or 5 lines in particular, it's a cardinal constitutional principle. The will of Parliament is expressed in the language used by it in its enactments. The proportionality of legislation is to be judged on that basis. The courts are to have due regard to the legislation as an expression of the will of Parliament. The proportionality of a statutory measure is not to be judged by the quality of reasons advanced, and so on.
But that's the point you made a moment ago, and in a sense, you could test it in this way, couldn't you? If you have a piece of legislation which is so obviously the right thing to be enacting, then Parliament may not actually debate it very much at all. May let it through, as it were, on the nod, because everybody, as it were, privately recognises that that is clearly the right thing to enact. And yet, if you couldn't possibly say, well, it wasn't debated properly. Which is, in a sense, there was an element of that in Mr. Coppell's submissions yesterday. You know, all we've got is Mr. Lawson and the stuff about Dick Taverne and all that.
What we've actually got is section 24(2).
Quite.
I mean, if one reads the Hansard passage in the bundle, which I did last night, I mean, it shows there was a lot of political
manoeuvring
going on there,
right,
and various ad hominem attacks and so on. But what, frankly, attaching any kind of weight to that at 3 o'clock in the morning is not something one would willingly do.
Right. So what you actually do is the wisdom in paragraph 67 is to start with, and it may be that it's self-evident having started with it, so you don't need to go further, the provision that Parliament has actually enacted. And you ask, in the light of that, what is the purpose, what is the aim that is sought to be achieved by reference to that legislation?
Yes.
I mean, we know that the Upper Tribunal went a bit further and looked at some of the pre-legislative material and looked at Hansard and broadly found it to be confirmatory of the conclusions that it drew. And we respectfully submit that there's nothing wrong with doing that, but it might be thought that all you actually need is 24(2), and that Lord Nichols in Wilson is so saying. See para 67. That's the first point, therefore. The second point is that ascertaining the legitimate aim of a piece of legislation or provision of legislation is a context and provision specific question. And the reason for emphasising that self-evident proposition is that other cases may well lead to different answers. You can't extract from the result or the conclusion in other cases anything about the objective aim and effect of a different set of provisions in a different context. So you look to the context and the provision that you're actually dealing with. Here, section 24(2).
Well, that was the point I was making about the Consumer Credit Act yesterday.
Yes, exactly. Exactly so. That's the second point. The third point is that it is plainly wrong, we submit, in seeking to ascertain the aim or purpose of the legislation, to approach aim or purpose at a level of abstraction which in effect requires the court to ignore core elements of the specific provision being dealt with. And again, that is, we submit, self-evident, but the reason for emphasising it is because that would be to ignore Parliament's evident aim. And the fourth proposition of principle is that there may, of course, be a variety of different purposes or aims which Parliament is driving at. There is no a priori limit on the number of purposes or aims any particular provision or piece of legislation might pursue. So that's the principled approach. What about here? What about our context and our provision? Well, reading section 24(2), it was evidently an aim to encourage private donations to political parties by the creation of an exemption. That is because that's the effect of the enacted provision. It was evidently concerned to avoid abuse, but it was equally evidently also drawing lines. Parliament did not enact a provision which simply provided open-ended encouragement, or where that was the sole purpose of what they were doing. And my learned friend tellingly and correctly, and I may add repeatedly, acknowledged that, as he put it, keeping the exemption within reasonable bounds, his phrase, was legitimate and necessary. Correctly acknowledged that, because otherwise you'd simply be ascribing to Parliament an intention and a purpose of creating an open-ended encouragement, which it plainly didn't do. And what that tells you is that the imposition of limits on the availability of the exemption and the concomitant decisions as to the nature of those limits is and was of the essence of the provision. Therefore, with its focus on Westminster, not, for example, local authorities in 1975, its focus on political parties, not just independent MPs, its decisions that there should be lines defining which parties qualified by reference to the general election, the last general election, one MP and so on. So what you can't do is to isolate one part of a carefully drawn, detailed scheme and exclude the other part as not corresponding to the purpose or aim. The lines are integral, and they are key to keeping parliamentary decision-making about what is appropriate in focus, and key to keeping the exemption, in Mr. Coppell's phrase, within reasonable bounds. And on that basis, we respectfully submit there is nothing wrong at all with the approach of the Upper Tribunal at 150, and the reference of the FTT at 109, the first tier tribunal at 109, the parties that participate meaningfully in the national political debate, was not merely simply manufactured by the FTT as a basic purpose, but it simply bears no relation to the terms and the detail of the provision as actually enacted by Parliament in section 24. So that's legitimate aim. I'm going, if I may, to take rational connection and less intrusive measures together, just because I think my learned friend did the same in his identification of the various factors upon which he relied. And I wanted to focus on two particular elements. The first of them is his factor 3. In other words, there have been numerous changes in the electoral system since Section 24 was enacted those years ago. And my submission in relation to that is that it doesn't indicate that the judgment that Parliament made at the time and continues to make is in any way outside the range of reasonable responses. But the focus on the changes to the electoral system since the provision was first enacted is double-edged from his perspective. And it's double-edged because despite those changes in other parts of the electoral system, the creation of devolved administrations and the European Parliament and so on, there has been no decision by Parliament to change the legislative scheme, with plenty of opportunity to do so. And that point is given even more force by the fact that the appropriateness and the possibility of reform of the current conditions has been considered in a number of reviews of party funding that have been undertaken since then. So you had the Neil report, which we were taking to yesterday, bundle 3, tab 58, particularly paragraph 8.23. You have the Electoral Commission report from 2004, bundle 3, tab 61, see particularly paragraph 6.54, and you have Sir Hayden Phillips's 2007 report in the next tab, bundle 3, at tab 62. We also know that following the Neil report, Parliament debated legislation to allow income tax relief for donations to political parties that would have used the existing condition, but that legislation was not implemented. You have the various debates if you really want them. Same bundle, tab 59. And it might be thought that the lack of change is not merely significant because it indicates that Parliament decided not to make any change, but it's also significant as indicating the intensely political nature of the issue which you are dealing with. And the fact is, the minimum fact is, that there has been no political consensus for reform of a kind that would take a new set of provisions through Parliament successfully. We add for good measure if focus is placed on the creation and existence of devolved administrations and the interposition into the electoral system of the European Parliament, that it is at least relevant to note, and this is the stuff of the two 4-page documents that accompany Uberina. It's at least to be noted, if you take up the one which has the black line on the top first, that's the domestic position. And you will see...
This is Institute for Government.
This is the Institute for Government website. Sorry, I should have made that clear, yeah. That's that one, and the other one is from the European Parliament website.
Mm-hmm.
And this one is the Institute for Government, and you'll see if you flick over to page 2, small page numbering on the bottom right-hand corner, bottom of the page, what funding is available to political parties from the devolved administrations. And then you will see a disparity of position as between the various devolved administrations, but at least some of them providing financial assistance to those who are operating within that devolved Parliament or Assembly sphere. So you see that the Scottish Parliament provides some funding, bottom of page 2, so does Northern Ireland, middle of page 3, and the Welsh are rather more parsimonious.
Thank you.
See 2/3 of the way down page 3. Could perhaps have said rather more careful with their public. And then the European Parliament, again, there's a bunch of detailed rules, but again, the basic proposition is straightforward, which is that there's some funding there. So we respectfully submit that his factor 3, the changes since the provision was originally enacted, really goes nowhere. And then we come to the structure, the second of the elements I wanted to focus on, to the structure and the content of the lines in fact drawn in section 24.2, which was the stuff of his factors 4 and 5. I wanted to make 2 overarching points in relation to that topic. The first of them is that I can make in the form of a submission, which is that the reasoning of Mrs. Justice Falk and Judge Herrington in the Upper Tribunal at paragraph 192, you can lay your hands on the UT judgment, 192, I think it's tab 7 of the main number.
Yeah.
And the submission that I wanted to make by reference to paragraph 192 on page 118 is that the Upper Tribunal approach there is correct, very important and well made.
Yeah.
The second overarching point is that once you decide you being Parliament for this purpose, that the political parties at Westminster is going to be the focus of your exemption, you have to define how that is to work. And so the second overarching point really builds on the correctness of the analysis at 192 of the Upper Tribunal's judgment. There are myriad ways in which that could have been done, or could be done in principle. MPs, numbers, popular vote, first past the post, general election or not. And those are, as I submitted earlier, legislative decisions on which the court really has no yardstick. Doesn't merely not have a yardstick, it would be constitutionally inappropriate, as the Upper Tribunal recognised in that passage. And so just to pick up some of the elements of it, section 24.2 does, at least in significant part, proceed on the basis of the first past the post system. My positive submission is that it cannot possibly be manifestly without reasonable foundation to use for the purpose of limiting the exemption the system which is the foundation of the electoral system in the United Kingdom for the Westminster Parliament. And if that is okay, if that is permissible, the rest is really numbers. Perhaps the second point to note about the first past the post system is that my learned friend, in truth, in his submissions, is fatally ambivalent on this. He says that he is not challenging that system. And he really has to say that. But he then does so by saying it's beyond the range of permissible legislative responses to use in the context of the limitation of the exemption. So that's the first past the post system. Section 24.2 is also done on the basis of elected MPs at the last general election. So it's elected MPs, not mere participation in the process of election. But that's just a different way of challenging the use of the first past the post system and not a number in terms of popular vote. And of course the focus of the provision, as we've seen, is on supporting MPs of political parties at Westminster. That's the first element within that one. The second element is it's the last general election, so it isn't by-elections, and it isn't crossing the floor of the House. The short and constitutional answer to that ground of challenge is that no doubt it could have been done differently, but this is a legislative choice. It was plainly a deliberate choice, given that it's clear from the face of the legislation that by-election and crossing the floor are out. It's the last general election. Is that choice beyond the range of permissible choices? We submit plainly not. It's perfectly coherent to say that the best way of gauging support for political parties is to be found in the last general election. And that will govern until there's a next general election. That was evidently the view. Crossing the floor, of course, is simply an MP's personal decision. As Mr. Churchill demonstrated, you can cross the floor any number of times. It's simply a personal decision. It's got nothing to do with democracy. It just happens to be the way that that part of the parliamentary process works. But so far as a by-election is concerned, again, one can postulate why they decided not to have by-elections in there. It's evident they did so decide, because that's the way in which the provision works. But one can see a perfectly legitimate judgment and view that that is not as good a measure, as reliable a measure, as using the last general election. Because by-elections, as Lord Justice Henderson pointed out yesterday, by-elections tend to generate their own particular political vortex, and the reliable measure, the more reliable measure it might be thought, is a general election. It's also perhaps to be noted in relation to by-election that even if you changed it in the way that my learned friend wishes, self-servingly, in order to bring himself within the exemption, It wouldn't make the legislation any less discriminatory. It would have resulted in the appellant not being liable to tax on most of the donations in this case, but a small party, it might be thought, would be just as likely to lose an MP through a by-election as gain one. And of course, as drafted, donors benefit from the exemption through the life of a parliament, even if the MP is lost through by-election. And if amended, that wouldn't be so. We respectfully submit, therefore, that those are perfectly acceptable and legitimate choices for Parliament to have made. Changing the point to take account of the result of the next general election after the transfer would, we submit, be very difficult to justify, particularly in the context of transfers of this kind, would in effect involve a system which created a gamble on the outcome of the next election.
Also, you're changing the nature of the objective, aren't you?
You are. You are. But my respectful submission is that the last general election gives you a block of support, a monarchy.
What you're seeking to do is to support, provide encouragement for financial support of parties at Westminster.
Exactly so. So a variety of different ways in which the thing could have been set up are advanced as indications of choices made by Parliament being outside the range of permissible responses. In the end, they are all driven, unsurprisingly, and I make no complaint about this, but they're all driven by the self-serving interests of Mr. Banks, who wants to bring himself within the exemption. But it might be thought, forensically at least, that they simply illustrate not a deficiency or an indication that those choices were outside the range, but rather that there's a whole variety of different ways in which this could have been done. And that emphasises that these are truly legislative choices, political choices about how the system should be set up.
In relation to the possibility of tying it to the results of the next general election, it was said there was some analogy could be drawn with the system of potentially exempt transfers under the IHT legislation. I mean, that struck me as a rather far-fetched analogy. I don't know whether you wish to comment on that. I mean, not least because, of course, that potentially exempt transfers didn't exist in 1975. I mean, that's one point. They were brought in the 1980s. But I mean, there the legislation provides specifically how the scheme is to operate. It's to take effect as an exempt transfer, and is only revisited in the event the donor dies within 7 years thereafter. So you have a legislative scheme which deals with futurity in as you would expect,
but in a very different way for a very different
way.
I think that's the short point to be made about that. The two are simply not analogous. Articles 10 and 11 I can take very, very shortly. The submission is that reliance on those articles really adds nothing. The points under Articles 10 and 11 were taken understandably very shortly by my learned friend, but we respectfully submit, really add nothing. The restriction on the availability of the exemption is not on the basis of opinion or association, but of the success of the political party, as I indicated yesterday and again this morning. The assertion appears to be made that the IHT charge was the equivalent of an ex post facto sanction for having exercised the rights to freedom of expression. We respectfully submit that there's at least a degree of, or a lack of clarity as to whether even making a donation was an exercise of freedom of expression in the central sense or real sense. But in any event, the IHT charge cannot possibly properly be regarded as a form of ex post facto sanction. It operates simply to exempt the person from the charge of tax that would otherwise be applicable. So there is no true analogy at all with any of the Strasbourg case law dealing with ex post facto sanctions. I have in mind in particular two authorities in Bundle 1, the Ezelin, E-Z-E-L-I-N case, Bundle 1, tab 10, and the Lingens and Austria case, Bundle 1, tab 9, in which are classic examples of that, in which the applicants in those cases exercised their rights to associate and express themselves, respectively, and were then punished for having done so. That's obviously fundamentally different. But in any event, even if there is engagement of either or both of those articles, the justification analysis we respectfully submit operates in substance in precisely the same way. You have exactly the same features and exactly the same factors that I identified earlier on that feed into the broadest possible margin in a context such as this for all of the reasons I gave. And the analysis under those articles is no different, either at the level of working out how significant the interference might be, assuming there is one. There's a broad church here too, for all the reasons I gave in dealing with suspect ground, but also in terms of the justification arguments. That leaves then only, I think, section 3 of the HRA, and the only point I wanted to emphasise orally is that the consistent authority at the highest level, including in particular in Gaydon and Mendoza, Lord Nichols, Bundle 1, tab 16, para 33 in particular, but the consistent authority at the highest level in relation to section 3, which, as you know, exists, as it were, in distinction to section 4 of the HRA, the Declaration of Incompatibility. The key thing to bear in mind is that the concept of possibility, which lies at the heart of section 3, connotes both linguistic or interpretive possibility and constitutional possibility. So you are required to ask the question, is it appropriate for the court to be interpreting the provision in this way, or is that a matter that constitutionally should be left to Parliament? One sees that in particular in the final part, I think, of Lord Anderson's qualifications to Mr. Glick's propositions in the Vodafone 2 passage. I don't invite you to go back to it, but you see that being flagged, as it were. But it's that constitutional element. Is it truly possible for a court to do this? And you bear in mind when doing that, the case that keeps coming back to mind is Lord Wolfe in Poplar Housing and Donahue, where he deals, I think, at paragraph 75 with the limits and approach to section 3 and makes clear that section 3 is still a rule of interpretation. And the reason for emphasising that is that there is a core distinction between judicial interpretation on the one hand, and the limits of propriety which that engages, and judicial legislation on the other. And that is informed by the constitutional debate. So if you conclude, well, this is all incompatible, this would be one of those areas we respectfully submit where section 3 simply could not be used, not least because there was 1,000,001 different ways in which this could be set up in response to a finding of incompatibility. Of course, you always have, which is why I emphasise.
So if we get to that stage, you say
section
we
4.
should limit ourselves to a declaration.
That's it. Yep. And I don't make any point. There's sometimes a desultory point to be made around whether you should exercise your discretion under section 4.
Understood. If we were that far down the line.
If you were that far down the line, it can't be
No.
something which can be fixed because there's a massive legislative choice still to be done. That's the short point.
Yeah. Okay.
Sorry, just a tiny point. You referred a few moments ago to Vodafone 2, and I think you said something about Lord Anderson, which puzzled me.
It was not David Anderson who was
Now Lord Anderson.
now Lord Anderson.
Oh, I beg
sorry,
your pardon, I see.
Mr. Anderson. I should have said.
Yes, sorry, I see.
Is he then
So it was a point made in argument.
It was, well, I think what the court did was to say here were Mr. Glick's submissions.
Oh, I see. Sorry.
Here were Mr. Anderson, who then was his submissions, by way of qualification. We broadly agree with both of them.
Yeah.
That seemed to be the basic.
Yes, I'm sorry. I'm with you now. Thank you.
Sorry.
Yeah.
Yeah.
Recent enablements always
Yes, indeed. No, sorry, I was thinking perhaps also of judicial Lord Anderson. I had
Yeah, no, I
was
should
having
say.
a sort of
Would have been easier if
a
I
brainstorm.
My lords, my lady, those were my submissions, unless I can seek to assist further.
No, thank you very much, Sir James. Yes, Mr. Coppin.
Just organise myself, if I may.
Yeah, sure.
My lords, my lady, Mr. Banks was taxed on his donations to UKIP when he would not have been taxed if he had donated to the Conservative Party or the Labour Party. As the First Tier Tribunal held, there is no material difference between holding a political opinion in favour of a party and donating to it. The latter is a natural consequence of the former. So then, this is, we say, a clear case of a difference of treatment based on political opinion. UKIP supporter taxed, Conservative Party supporter not taxed. Now, Sir James mounted a persuasive case that Section 24 of the Act does not treat people differently according to their political opinion, but rather according to the political success of the party to which they donate. He says it's not the political opinion which matters, it's the success of the party at the last general election. Now, as is often the case when listening to Sir James, I was persuaded that he was absolutely right in that submission. Section 24 does draw a distinction on the basis of political success. But he is right about the wrong thing. The point is this: Section 24 does, as I've just said, distinguish between parties on the basis of their electoral success, but it distinguishes between taxpayers on the basis of the parties which they support and therefore donate to. Now, whether you have a schedule to the Act, as I suggested as an alternative legislative technique, or you just have a page on the HMRC intranet, every 5 years, Section 24 requires a new categorisation of parties, a new list, those parties to whom donations will be exempt, not exempt. So far as the donor is concerned, it doesn't matter how that list is drawn up, whether it's on the basis of electoral success at general elections, whether it's on the basis of the number of party members, whether it's on the basis of whether the party's name falls in the first half of the alphabet. Doesn't matter. What matters to the donor is that there is a list, and if your party's on it, your donation is exempt. If it's not, your donation is subject to tax. My case, of course, is concerned with the donor and the donation. And the tax treatment of the donation depends upon the party to whom it is given at the time that it is given. Conservative Party, yes. UKIP at the material time, no. The criteria...
No, it doesn't. It depends upon the success of the party at the time, as demonstrated by the fact that the two, if Mr. Banks had donated in 2016, his donations would have been exempt.
The criteria...
It's not just the party, it's the success or otherwise of the party.
Yes, well, my point is this. So far as the donor is concerned, it doesn't matter what the criteria are. What matters is if he wants to give to the Conservative Party, he's exempt. If he wants to give to UKIP, he's not exempt. That's what matters for the donor. The criteria which are used to draw up the list, success of the last general election, well, that goes to justification. That goes to whether it is justified to treat donations to some parties in a different way from donations to other parties.
But aren't you jumping ahead by going to, as it were, saying it all goes to justification? Because there's the prior point, at least as Sir James was putting it, as to whether you have a necessary causal link between the criterion employed by the legislation and the difference in treatment which we are talking about.
Yes, and what I'm asking the court to do is to focus on the donor and the donation, and the relevant causal link is simply is established simply by the identity of the party to whom the donation is made. Mr. Banks wanted to donate to UKIP, therefore, because of the list at that particular time, he was taxed.
But the list was entirely dependent upon success at the last general election, or absence of success at the last general election.
Yes, it was. But my point is, so far as the donor is concerned, that doesn't matter. What matters is that he's a UKIP supporter, he wants to donate to UKIP and he will be taxed. Whereas if he wanted to donate to the Conservative Party, he wouldn't be taxed. So for the purposes of the donor, his political opinion matters. Who he wants to donate to matters. I gave the perhaps somewhat flippant example of where the party comes in the alphabet. Parties in the first half of the alphabet are exempt, and those in the second half are not. Would have the same effect. I'm sorry, would be the other way. Yeah, yes, the same effect. Conservative Party exempt, UKIP not exempt. That has no practical consequence for Mr. Banks. The practical consequence is he wants to donate to UKIP and he's taxed. If he was donating to the Conservative Party, if his political opinions were different, he would not be taxed. So that's the difference of treatment, and it is a difference of treatment which turns on the political opinion of the donor. And then the court has to ask, well, is that difference of treatment a justified difference? And we get into aim, and well, to which Sir James can say, of course it's justified, he would say, to draw up the list on the basis of electoral success at the last general election for all the reasons he gave. But that's at the discrimination stage, at the difference of treatment stage, that is in our submission the wrong focus. The focus is on the donor, his political opinion. That's what Section 24 does. In terms, it focuses on transfer of property by the donor, which will be exempt or not exempt according to a list. The criteria for which, at this stage, are not determinative. Now, there were two other difficulties with my learned friend's submissions for the purposes of this first difference of treatment argument. Firstly, my learned friend's submissions did rather focus on form over substance. He said you can't know from the face of the legislation to which donations it applies and which not. And therefore he says it's not facially discriminatory. But at the material point in time when a donation is made, you can tell from the face of the legislation to which donations it applies, which it doesn't. You just look at the last general election results. And that's my schedule point, it's purely a matter of form over substance. You could have with the same effect, a schedule to the Act that was facially discriminatory in my learned friend's terms, because it actually sets out the parties who are exempt. But it doesn't matter, because that's the practical effect. That is the effect of Section 24 at any point in time. And really, that's the second further problem with my learned friend's submissions. He accuses me of wanting to freeze the analysis in time. He says, well, you've got to look at the fact that UKIP did qualify after the 2015 general election, and that shows it's not discriminatory, and Mr. Coppell wants to freeze the position in time. Well, the court, in my submission, is required to look at the position at a particular point in time when the donations are made. That's when discrimination either happens or it doesn't. So it's not me that's freezing the analysis in time. That is the legislation. Your donation will be exempt or not exempt depending upon the circumstances at the time that you make it. So far as indirect discrimination is concerned, I didn't apprehend any real difference in substance as compared to what Sir James said about direct discrimination. He said, well, it's political success, and that doesn't have a disproportionately prejudicial effect on anyone. And my answer is the same. So far as the donor is concerned, it's which parties qualify and which don't. If you're not persuaded that that's direct discrimination, because of some arguments about facial neutrality or not sufficient close proxy or whatever, then it should, in my submission, follow that it's indirect, because all UKIP supporters are taxed, whereas supporters of other parties may or may not be taxed, and chances are won't be, because the major parties are exempt. And on the third ground, the reliance on the status of UKIP. So far as the status is concerned, and we rely on the status of having MPs in Parliament, which was the basis on which UKIP didn't qualify. There's the independent existence condition that my learned friend relies upon, and he says, well, if that status didn't exist, you'd have to invent it, he said. That's not a good answer to the submission, to our case, because, as has been frequently pointed out in the case law, including by Lord Mance in Stott, cited, and I'll just give you the reference, cited by Lord Justice Leggett in C at paragraph 67 on page 1548. As Lord Mance put it, there is no reason why a person may not be identified as he says just above letter G, on the other hand, there seems no reason to impose a requirement that the status should exist independently in the sense of having social or legal importance for other purposes or in other contexts than the difference in treatment complained of. He cites Lord Mance in Stott. So it's not an obstacle, it wouldn't be an obstacle if the status that I was relying on was one that arises only out of the terms of the statute itself, or wouldn't have arisen but for the terms of the statute itself. So that's para 67 of C. But my short and practical answer to this submission is the majority judgment in TP, having MPs elected to Parliament being a matter of fact which has various types of implications in the real world. That was the basis of the majority judgment. My learned friend relies upon Lord Justice Rose's minority analysis, which is more detailed and more sophisticated than that of the majority, but I can rely on the majority. Ultimately, Lady Justice Rose's reasoning was driven by the same point which the first tier tribunal made, as you'll recall, about protection requiring to be practical and effective and not illusory, and the drawing of fine distinctions, such as the respondents have sought to draw in this case, goes against that. On associative discrimination, so the next step is UKIP has a status. We say that Mr. Banks can rely upon that status. We submit that is an argument within ground 3, as pleaded in the notice of appeal. It is, I accept, a slightly different way of putting the argument than we put it in our skeleton, but it is a simpler way to the same point that we've made in ground 3. My learned friend sought to address the point as a matter of substance by taking you to 2 cases. One was the Lindsay case, tab 11 of bundle 1. I'll ask you to turn that up, please. And this is, of course, not about associative discrimination at all. It's 20 years before the Court of Human Rights recognised associative discrimination. But it's about victim status, which is the way that the argument was put below, that UKIP has been discriminated against and Mr. Banks can rely upon his status as he can rely upon the breach of UKIP's rights because he's the victim of those rights. That's the alternative way that we put ground 3. But that was the point in Lindsay, that the applicants weren't victims. There's no Article 14 associative discrimination point at all. And the reasoning of the Commission, just to date the decision further, in the 3rd paragraph up from the bottom of 137, in the final sentence, the Commission has not been given any information which could indicate that any of the applicants has been subjected to discriminatory treatment in the enjoyment of his convention rights or at all. And the point was that there wasn't any sufficient connection between the applicants and the political parties, so as to allow them to say that they were victims. But of course, Mr. Banks has a much closer connection because he was taxed. He is to pay the tax as a result of donating to a particular political party. He has a connection and he is directly affected in a way which the Prince and Lindsay simply weren't. And the other case that my learned friend took you to was Guberina, which is the authority relied upon in Simawi by Lord Justice Lewison. And if I could ask you just to take that up, he showed you the relevant passage between 76 and 79. And he relied on 79 in particular. The court therefore finds the alleged discriminatory treatment of the applicant on account of the disability of his child, who has close personal links and for whom he provides care, is a form of disability-based discrimination covered by Article 14. And that is the application of the principle of associative discrimination in that case. But the principle is in the final sentence of 78 and is a broad principle. It thus follows, in the light of its objective and nature of the rights which it seeks to safeguard, that Article 14 of the Convention also covers instances in which an individual is treated less favourably on the basis of another person's status or personal protected characteristics. It's a broadly stated principle, nothing to limit it to disability or to adults relying on child status. It's a broadly stated principle. Indeed, Lord Justice Lewison in Simawi said he didn't see why that couldn't apply as between an adult and their parent. But the principle is a broad one, and I rely on the principle. I'll then, following the order of my submissions, rather than those of my learned friends, Article 10 and 11, he said I took these arguments shortly. Well, I did take them shortly because they are obviously instances, or the argument is a short and obvious one based on the findings of fact made by the FTT, which aren't disputed, that giving to a political party is a form of political expression. So James said that there was some lack of clarity in this case as to whether making a donation is an aspect of freedom of expression. Well, there isn't. That's what the tribunal found. That's what we say. His other answer was, well, this is nothing like a sanction on freedom of expression like Ezelin or Lingens. But the only reason we cite those cases is to rebut the fallacious reasoning of the Upper Tribunal along the lines of, you gave the money anyway. That was a large part of their reasoning on Article 10 was you weren't deterred, you gave the money anyway. That is simply wrong in principle, and those two cases are examples of ex post facto interference with freedom of expression. I'm not saying this case is on all fours with either of them. They just go to rebut the reasoning of the tribunal. And take a slightly different scenario. What if there were a tax on political meetings? Every political meeting held by a party would be taxed by those who attended it, or taxed on those who attended it, unless you were exempt on the same criteria. It's an obvious interference with freedom of expression. Even though people might go to the meeting and pay the tax, this is exactly the same. It simply relies on a slightly different form of expressing support for a political party. Now, the reason why my learned friend takes this point last and put it in quite the way he did is because it's a difficulty for the respondent's case on margin of discretion. They cannot show you any authority which applies manifestly without reasonable foundation or any broad test of margin to freedom of expression. On the contrary, the approach of the Strasbourg Court and of our domestic court, and you see it in the Ezelin and Lingens cases again by way of example, on the contrary, the approach is that there is a very narrow or non-existent margin of discretion for restrictions on political expression, interference with political expression. Now, of course, it all depends on the context, and I'm not going to say there's no margin here, but it's a million miles away from the social welfare benefit, economic and social policy, which is the territory on which my learned friend wants to fight the case. Now, he may say, I think he probably did say, well, this isn't a very serious interference with freedom of expression. It's just a tax, and it only affects a limited number of wealthy people. He may say that, and that goes to proportionality. But he doesn't get the benefit of the margin, which he wants under Article 14. So that's Article 10, and same points apply to Article 11. I then come to the question of margin. My learned friend said that the DA case had put to bed the question of whether the manifestly without reasonable foundation test only applies to certain limbs of the proportionality, the four-legged proportionality test, but not to other limbs. Well, far from it. It hasn't put that to bed, hence, or didn't put it to bed, hence Drexler, hence JCWI, which I'll come on to in a moment. But it is still a live issue and will be until, at least until the C case in the Supreme Court and probably thereafter. It is still a live issue as to what is the correct approach in cases other than cases concerned with welfare benefits.
Sitting in this court, though, I mean, aren't we really bound to follow the approach followed in the two recent decisions
Of the Court of Appeal?
of the Court of Appeal, Drexler and JCWI?
Well, yes, I mean, it is my submission that you should follow what they say, but what they say is not by rote, manifestly without reasonable foundation.
Yes.
And I'll show you particular paragraphs that I rely upon, and I'll come to it now. So in the context of Article 14, in Drexler, we say it's paragraph 76, which is critical. So it's tab 53. And it's 1996.
Tab 53.
Sorry, tab 53.
Yeah.
Yes,
Yes.
53.
Paragraph
Page
76.
Paragraph 76, 1996. So this comes immediately after the analysis whereby Lord Justice Singh has rejected the argument that manifestly without reasonable foundation only applies to social security legislation cases. He's rejected that, and he's referred to some other cases in 71 to 73.
Yeah.
But this particular case was a case about a local authority restricting its provision of welfare services on grounds of allocation of scarce resources. So plainly, mostly analogous to the larger scale legislation cases. The 76 is the crucial point. Really, it's a matter of context and the extent. So it's he describes the context as one in which a public authority is required to allocate finite resources and chooses priorities when it comes to setting its budget, and also a non-suspect ground. So no material difference. And that is essentially the same point as is made in JCWI, paragraph 140. So it's the next tab. Paragraph 140 on page 2047. Well, Justice Hickenbottom has said, properly construed, the second sentence, in my view, the criterion cannot simply apply to some cases where there's an issue of justification in respect of a measure involving an element of social or economic policy separated from other cases by a bright line. The degree of social and economic policy involved in any measure will be infinitely variable. In my view, the criterion recognises where there is a substantial degree of economic and or social policy involved, the degree of deference to the assessment of the democratically elected or accountable body that enacts the measure must be accorded great weight. The greater the element of economic and or social policy involved, the greater the margin of judgment. So that in my submission is where we are. There isn't any authority that the manifesto without reasonable foundation test must apply to all cases, including cases outside the social security legislation context. But where this court has arrived at is the perfectly sensible position that the margin depends on the amount of economic or social policy involved in the particular measure, as well as other factors such as the ground of discrimination.
We may say it's only obiter, I suppose. I mean, that may be the point you're trying to make. But as I read both the judgment of Lord Justice Singh and the judgment of Lord Justice Higginbotham, they have said that it's not limited to welfare benefit in terms. And Lord Justice Singh identifies 3 other cases in the Court of Appeal at that stage where manifestly without reasonable foundation being applied outside the sphere of welfare benefits.
Yes.
And it's the point that Lord Justice Higginbotham makes at 134. He says in terms, if I had to decide it on the basis of manifestly were that test, is that test applicable, I'd decide it was.
Yes. But that is, again, because of the context of the particular case. What there isn't is any authority that manifestly without reasonable foundation is the test, say, for all Article 14 cases.
No, nobody, Mr. James isn't suggesting that. The point, as I understand it, what he's saying is either because this is taxation, or it's exemption from taxation, but it's the same thing, it's the reverse of the coin, it's part of economic policy. Alternatively, he says that the caution that is exercised by the court in those paragraphs you referred us to on the grounds that these are matters of social and economic policies for Parliament is equally applicable here, because this is a political, quintessentially political decision by Parliament. So even if you say it's not social and economic policy, it's political.
Yes.
and that's not a matter that the court should go anywhere near putting it colloquially. And that's essentially his case.
Yes. And all I'm seeking to submit at this stage of my argument is there are various points of context, and I'll come to his points of context shortly. There are various points of context which one has to look at in order to establish whether there's a broader or lesser margin, but you don't simply plump for manifestly without reasonable foundation because this is we'll say a tax case, without looking at what sort of tax case is it, to what extent is this economic or social policy, or is it a measure directed to the functioning of the party political system, which is my submission, and I've got other points on context that I'm going to come to now. So it's my point is simply you don't just reach for the manifesto without reasonable foundation test. You've got to look at the circumstances of the case and ask how much economic or social policy in particular is involved. And of course, even if this were a case of manifestly without reasonable, or a case where the manifestly without reasonable foundation test applied or something similar, that wouldn't mean that the court is thereby entitled to do what the Upper Tribunal did, which is essentially to say this is all very difficult and sensitive, case dismissed. And there's something of that theme in my learned friend's submissions. You just ought not to be looking at this at all, was where it seemed to be heading. And that is indeed where the Tribunal got to. But it's paragraph 66 of DA in tab 45, bundle 2. It's a well-known passage, or often cited passage, even in a relatively short period of time since the and it's letter H on page 1598. Where having made his decision that the manifesto without reasonable foundation test applies at all stages.
Sorry, which paragraph?
66.
66.
11598.
Yep.
Letter H, he explains what the test means. The court will proactively examine whether the foundation is reasonable, and it is fanciful to contemplate its concluding that although the state had failed to persuade the court that it was reasonable, the claim failed because the complainant had failed to persuade the court that it was manifestly unreasonable. So even if we were in the broadest margin territory, there has to be a proactive examination, and it's like different ways in other cases, a proactive examination of the justification to whether the state has persuaded the court that this is reasonable. So one simply can't do what the Upper Tribunal did recently, and not investigate the detail at all.
Well, surely that depends on how you characterise the question. I mean, if it is a question that turns on the making of purely political choices, then I can't see what's wrong in saying that's just a no-go zone for the courts.
Well, the courts, as Lord Wilson's dictum suggests, and as is been made clear in the landmark Human Rights Act judgment,
Yes.
Guy Dan, courts have a duty to examine the compatibility of legislation, and that duty is structured in a case which raises justification issues. It is structured by reference to a well-established four-stage test, and you have a lot of guidance, as we've just been discussing, on the intensity of review in the four-stage test. But you still must go through the four stages, and I'm going to take you through them in a moment, and ask whether the justification is made out at each of those stages, and it cannot be an answer that we're just not going to look at it at all because it's too sensitive. So what I will submit before I get to the four stages is my learned friend, and this is his part of his margin context. He said, and I think it's perhaps a point inherent in what my lord has just put to me, it was not possible for the court to say what choice Parliament should have made. And I agree with that. And I'm not asking you to do that. You were shown paragraph 192 of the Upper Tribunal's decision discussing the alternative mechanisms which my learner junior had proposed. And I agree with 192 as well. In the context of justification, the tribunal said its task is to identify whether the conditions in section 24(2) have a legitimate aim, and whether, if the test is adopted in asbestos and AXA applies a fair balance, has been struck. That does not require the measure adopted to be the only, or even what the tribunal might view as the best way of achieving a fair balance. The line has to be drawn somewhere, and within the limits just indicated, it's for Parliament to decide where to draw that line. I don't put forward.
So that amounts to saying that if we get to that stage, we shouldn't engage in the Section 3 exercise at all. We should simply say, make a declaration of incompatibility.
Well, that's this.
That's the logical consequence of what you've just accepted, with respect. I mean, if you accept what was said, where the line is drawn is a matter for Parliament.
Well, no.
Then the Section 3 interpretation route involves us saying, well, in effect, we, the court, will draw the line somewhere else.
So the critical part of the last sentence, and as is prompted by the previous sentence, the critical part of the last sentence is within the limits just indicated. And that's really the nub of my submissions, is yes, primary legislation is a matter for Parliament, but there are limits. And the limits which I'm asking you to consider are the limits set by the four stages of the proportionality test, including legitimate aim and fair balance, which are mentioned by the tribunal in the previous sentence. Now, I accept that once you get to Section 3, then my learned friend is entitled to say, well, the court can't decide what the best way of doing things is, but that's not the question at the Section 3 stage. The Section 3 question is whether it is possible to remedy or to avoid the breach of convention rights which applies in the claimant's case. How the legislation may be changed in the future will be a matter for Parliament. But the question for you is whether it is possible to read the legislation in a way which avoids breach of convention rights in this case. So what are the limits? And it's the four-stage test. And we start with legitimate aim. Now, my learned friend accepted that there was a difference in the relevant aim, in principle, depending on whether it was a case of direct or indirect discrimination. Direct discrimination, the question is, what is the aim of the difference of treatment? Indirect, what is the aim of the measure as a whole? But having accepted that, he then didn't identify what he says is the aim of the difference of treatment. What is it? It's not channeling funds to political parties. That's the aim of the measure as a whole, subject to certain additions, which I'll come to. What is the aim of the difference of treatment on his case? He didn't give you one. He just said, well, you've just got to look at what the legislation says. Now, it is not, with respect, the right approach to just look at what the legislation says. What Lord Nichols in Wilson said was you look for the underlying social purpose of the legislation.
But isn't the aim of the difference in treatment to ensure that the relevant encouragement to donate to political parties is limited to those political parties which are already participating in the Westminster Parliament?
That is the difference of treatment, my lord. That's not the aim of it. That is it.
Why?
What is the aim? What's the objective in establishing that difference of treatment in the legislation?
On the basis that that's where the line is drawn, I must confess I'm having great difficulty in seeing what point you're seeking to make.
Well, we submit that,
because if what you're saying is look at the next general election, it's the point I made to Sir James this morning. If you draw the line at the next general election, you're changing the nature of what the aim is. You're changing it from being to as it were to promote the existing parties at Westminster and to ensure that or to encourage financial support for them, to saying, well, it's not just the existing parties at Westminster, it's those parties who may gain a seat at the next election, even though they haven't yet done so.
Yes. And well, look, there's a real danger, and it's sure not part of my learned friend's purpose in the way that he made his submissions, is to ask you to look at one stage of the test with reference to some of the others and kind of jumble it all up together and ask yourself whether this is a good idea or not, or was Parliament entitled to think it was a good idea. One has to look at it systematically in our submission, and the first question is, what is the aim of the difference of treatment?
Well, can I suggest one possibility? I mean, I think Sir James said, and I think you indeed said yesterday, you accepted that the exemption couldn't sensibly be completely open-ended. There has to be some limit on it. And if you accept that, then the general aim could be the imposition of reasonable limits on an exemption which would otherwise have no limits at all. I mean, so that could be, if one wants to generalize, an example of the overriding, or rather the underlying purpose, which could then be satisfied in goodness knows how many different ways, depending on really political choices. I mean, that seems to me a at least I'm throwing it out as a possible answer to your challenge, which is to identify an underlying purpose for the difference in treatment.
Yeah, so...
Because there's always going to be a difference in treatment, isn't there? Unless it is completely open-ended, there's always going to be a difference in treatment. Because even if you drew the line at the next election, if UKIP hadn't won any seats at the 2015 election, Mr. Banks would be saying, "Oh well, you shouldn't have drawn the line there. You should have drawn it somewhere else. Number of MPs in Europe or something of that kind."
But my lord, it's look. I mean, first of all, go back to the first tier tribunal. He said, prevention of abuse, and I submitted that as a finding of fact, based on the submissions made to the first tier tribunal by the HMRC.
Well, it's only a finding of fact in a very odd sense. I mean, it's not as though anyone could, as a matter of fact, you can only deduce the purpose of any legislation really from the terms in which it is expressed and the context. And that's really an issue of law, not one of fact.
It's not a finding of fact. It's an issue of interpretation of the relevant statute, isn't it? And the submission was, well, this is the purpose of the aim or the purpose of it. The revenue said one thing, your client said another, and the decision as to which is the right one is an issue of interpretation of the statute, which is, my friend, as my Lord says, is a question of law.
Well, it's not simply interpretation of the statute with respect. It is what is the aim of the legislation, which of course turns in part on what the statute says and on other factors, as we've heard, as well. But the first tier tribunal, adopting the submissions which were put to it by the HMRC, made a finding that the purpose of this provision is encouraging flow of private funds to political parties whilst preventing abuse. Now, preventing abuse is, you may say, well, that isn't finding a fact, and it's open to be looked at again. But was this an error of law which the Upper Tribunal was entitled to interfere with? We say no. But even if it was, what preventing abuse does is it puts a proper objective around reasonable bounds. Why? In my submission, it wouldn't be enough to simply say the objective is to keep the exemption within reasonable bounds. Why? What's the purpose of keeping it within reasonable bounds? What is it? Is it to save money for the revenue?
If the objective is to prevent abuse, how do you go about preventing abuse other than by some form of limitation such as was adopted?
Well, my lord, I entirely agree, but you have to start by identifying the objective, and then stages 2, 3 and 4, you measure what the statute actually does against the objective. Now, if the objective is preventing abuse, let's just go with that for a moment. If it's preventing abuse, then stage 2, is there a rational connection between preventing abuse and limiting the exemption to parties who had seats at the last general election? Well, possibly. You're narrowing the field, keeping it to serious parties. Is there a rational? Is there a less restrictive means of preventing abuse than simply giving the exemption to parties which succeeded at the last election? Well, of course there is, because there are perfectly reputable parties, serious parties, active in lots of different ways on the national political scene, to which it wouldn't be abusive to make donations. As the Neil report said, what you don't want is to allow exemption to every political party which is registered, because then people will be able to register parties in the straightforward way that one can do that as a tax avoidance measure. But if the objective of the difference of treatment is preventing abuse, there really is clearly a much less restrictive way in which you can do that, and fair balance then also has to be measured against the objective. If there's no serious question of abuse by giving to UKIP, which has 1 million votes and 2 MPs in by-elections and so forth, if that's not on any sensible construction abusive, then there can't be a fair balance struck by the legislation. So it all depends on what your starting point is, what your aim is. And my learner friend didn't, with respect, identify the aim of the difference of treatment, because as soon as he starts to do that, the second, third and fourth stages of the test become more difficult. Much easier to look at it all in the round. It's very sensitive, difficult for Parliament, lines have to be drawn. No, you've got to identify the aim of the difference of treatment.
I mean, that raises the question of what abuse would mean in a fiscal context like this. And on the face of it, if you have a political party and one has freedom of expression allowing one to support political parties of any complexion, how can you say it's abusive to make tax-free gifts one rather than another?
Well, the Neil report addressed that point. I showed you the reference yesterday, yes. Which is partly where the First Tier Tribunal got its abuse point from. And that would be a perfectly understandable objective and a perfectly understandable concern that people could use the system to avoid tax by establishing political parties.
Well, we all know there are fringe political parties, the monster raiding loony and things like that, which probably aren't taken seriously by very many people, even if they are technically, I don't know whether in fact it is or not, registered as a political party.
It is.
It is, yes.
Well, my lord, it may just go beyond any registered political party, and there may be some other criterion aimed at a party like the monster raiding loony party. But we're talking about a party with very substantial national support, with seats in devolved legislatures, seats in the European Parliament, and seats from by-elections. By no stretch of the imagination is it abusive to give to a party like that. So I would urge the court to ask, to identify what is the aim of this difference of treatment, and then to take the test systematically. And of course you have to incorporate an element of margin into that, but you do have to consider this is political opinion, this is a freedom of expression case. And some of what my learned friend was saying about parliamentary consideration and what had and hadn't been done by Parliament, in my submission, went much too far on the authorities for him to say that Parliament has decided not to change the legislation. It's simply the wrong way of looking at it. Parliament has not been asked whether to change the legislation or not since 1975.
Well, Parliament enacted the Inheritance Tax Act in 1984, so at that stage Parliament had the opportunity of drawing the line somewhere else. There's then the Neil report. There was then, as I understand it, though we haven't really looked at it, and I'm not inviting you to take us to it, but there was some parliamentary debate about whether to introduce income tax relief on the same basis, which is what the Neil report had recommended, but that in the end that was not pursued. So to that extent there's been parliamentary debate, and and that's as far as it goes.
But one can't say, oh, there's been lots of reports. The government of the day didn't put the proposals from the reports before Parliament. Therefore, you should be influenced by Parliament not having decided to adopt the terms of the reports. On the authorities, in my submission, the appropriate question is whether Parliament has considered and grappled with the particular issues raised by the Convention Rights Challenge, and that's paragraph 158 of SC, which my learned friend relied on. I think both of us may have relied upon it. It goes to intensity of review, whether Parliament whether Parliament or whichever other the decision maker was, has identified and grappled with the relevant issues. An absence of grappling is not a factor to enlarge the margin. Quite the opposite. So if you follow the test through, identify the aim, follow the subsequent stages in asking whether the aim of the difference of treatment passes muster under those stages with an appropriate margin, as I've submitted, we submit that you should find that this is simply an anachronistic provision enacted in very different times, which is not suited and can't pass the proportionality tests 50 years later in the circumstances in which we are today. So far as Section 3 Human Rights Act is concerned, I simply say what I'm asking is a lot less than what was achieved in the Vodafone case, and I'm asking you to rectify, to avoid the breach of convention rights in my client's case, which can be done in various different ways, and it will be up to the government and Parliament to decide what the position should be for the future.
I'm a little troubled by the suggestion that a Section 3 construction can, as it were, be tailored to the particular circumstances of the individual appellant. I mean, the theoretical consequence of that is you would have a whole host of different conforming constructions which the courts have had to, as it were, produce in order to deal with facts of individual cases. And that surely would be a situation of real legislative chaos. You had a whole number of ad hoc, bespoke constructions all competing in the field at the same time, just to cater for the facts of individual cases.
Yes. Well, I mean, put like that, my lord, that might be a problem.
But isn't that the logical consequence of what you're asking us to do?
Well, the duty is to construe the legislation as far as possible in accordance with convention rights, which means the convention rights relied upon by the claimant under section in section 6 case. That's your target, as it were. You're not concerned to adopt an interpretation which would be sufficient to avoid the full range of possible breaches of convention rights, most of which aren't before you. And if there is really any problem with the possibility of another different interpretation having to come forward in a different case. Well, the government has Section 12 remedial order powers. It has the option to seek a reform of the legislation for the future. But it is the statutory target under Section 3 is my client's convention rights.
Yes. Yeah, thank you.
So, my lords, my lady, those are my submissions, unless I can assist further.
Thank you very much, Mr. Coppell. Well, thank you both very much, and to those behind you for the extremely cogent and helpful submissions. Obviously, we're going to reserve judgment. You'll get the draft in the usual way for pointing out any typographical and similar errors, not for inviting us to reconsider argument or to re-argue the case. And it's in all likelihood the judgment will be handed down remotely as I have been. So if you can possibly agree an order beforehand, we'd be grateful. If you can't, then written submissions as to any points that are outstanding, and we deal with it on paper. But once again, thank you all very much.
Rise.